Hi, my name's Gavin and I'm the Senior Managing Solicitor of Emerson Family Law. Today I'd like to talk to you about recent changes to domestic and family violence law in Queensland, what you need to know. So why the changes? The new changes to the law, namely the Domestic and Family Violence Protection Act 2012, being the governing piece of legislation in Queensland, is in response to a report which was prepared by the Special Task Force on Domestic and Family Violence in Queensland in February 2015, aptly entitled Not Now, Not Ever, Putting an End to Domestic and Family Violence in Queensland. The report had 5 main policy objectives which brought about the new changes. Firstly, to provide victims of domestic and family violence with access to earlier and more tailored protection. Secondly, to ensure victim safety is at the forefront of the justice response to domestic and family violence. Thirdly, requiring the police to consider how immediate and effective protection can be provided to victims pending a court's determination or consideration of an application for a domestic violence order. Fourthly, to provide for the automatic mutual recognition of domestic violence orders made in other Australian jurisdictions through the National Domestic Violence Orders Scheme. And fifthly, to hold perpetrators of domestic and family violence more accountable and encourage them to change their behaviour. So what are the changes? There are 11 changes to the Domestic and Family Violence Protection Act, which came into effect on the 30th of May 2017. Today I'll be highlighting 5 of those 11 changes which you need to know. Firstly, the grounds for a domestic violence order, or a DVO. Under the law, victims can be protected by a DVO if a court is satisfied that, among other things, the respondent has committed domestic violence against them. The current definition of domestic violence is broad and includes behaviour that is threatening or coercive, or that in any other way is controlling or dominating, causing a person to fear for their safety or well-being or that of someone else. However, the use of the phrase has committed domestic violence can create a misperception that an act of physical violence must occur if all victims can obtain a DVO. The new changes now clarify that a court can issue DVOs on the basis that victims have been threatened or have a fear that the respondent will commit domestic violence. The second change, tailoring conditions in a DVO. All DVOs typically include standard conditions: that the respondent must be of good behaviour towards the aggrieved and any named person and must not commit domestic violence. The court has discretion to impose other conditions that are necessary or desirable in the interests of the aggrieved, any named person, including any child or children or the respondent. The new changes now make it mandatory for the court to specifically consider the making of other conditions for the protection of the aggrieved or any other person, including any child or children. Previously, the court only had the discretion to impose further orders, whereas the legislation now requires the magistrate to turn their mind to imposing other conditions at the time of making the DVO. To achieve consistency with the test for making a DVO and improve victims' ability to obtain tailored protection, the new changes now, firstly, explicitly require the courts to consider imposing additional, more specific conditions should be included in the order, and secondly, require the court to consider what other conditions are necessary or desirable to protect the aggrieved or any named person from domestic violence. The third change, the duration of a DVO. Prior to the new changes, a DVO typically lasted for up to 2 years, unless the court was satisfied there were special reasons for imposing a longer duration. The task force identified that the review of the Act should consider clarifying the circumstances in which a protection order may be extended beyond 2 years. The new changes now broaden the court's discretion to determine the appropriate length of a DVO and clarifies that the paramount principle in determining the appropriate duration of a DVO is the safety, protection and well-being of the victim. If a court does not specify the duration of a DVO, it will remain in force for a minimum period of 5 years from when it was made, unless the court is satisfied there are reasons for making an order that lasts for less than 5 years. Strict interpretation of the new changes seem to indicate that the 5 years enforcement period came into effect on the 30th of May 2017, albeit a retrospective protection order application being filed prior to this date. The amendments make it very clear that the enforcement period will run from the time that the protection order is made, being either at an interim stage or at a final hearing. The new changes now provide that where there is a variation application to reduce the length of a DVO, the court may only make the variation if the court considers that there are reasons for doing so. The paramount principle in determining such an application will continue to be the safety, protection and well-being of the aggrieved and any children or named person. The fourth change, consideration of family law orders. Prior to the new changes, the court has had a broad discretion to consider family law orders that they are aware of and to consider using their powers under the Family Law Act 1975 to modify or suspend the order in light of the proposed conditions of a DVO. The task force noted that victims are often faced with DVOs and family law orders that have inconsistent terms dealing with living or spend time arrangements between parents and children. The new changes now strengthen the current obligation by requiring a court to always consider any family law order that they are aware of and to always consider whether to exercise their power to resolve any inconsistency between the order and the proposed DVO. And the fifth change, the National Domestic Violence Scheme. A DVO made in any Australian state or territory on or after 25th of November 2017 is now automatically recognised and enforceable in each other state and territory. No further action is required. They are automatically nationally recognised orders. The recognition applies to any DVO made by a court or police officer that is declared by the regulations of the respective states and territories to be an interstate order. They include final orders, interim orders, and various other types of protective mechanisms which are available, for example, release conditions and police protection notices. However, a DVO made prior to the 25th of November 2017 is different. To be recognised and to be enforceable in a state or territory other than the one in which they were made, a discrete application must be made for registration in each other state or territory in which protection is sought. So for example, if a DVO was made on the 24th of November 2017 in New South Wales, and the aggrieved has since moved to Queensland, the aggrieved would need to make an application in Queensland for registration of the New South Wales DVO for that order to be legally recognised and enforceable in Queensland. A nationally recognised DVO prevails over an earlier comparable local order or comparable interstate order, and the earlier orders stop having effect. However, if a new nationally recognised order does not extend to all of the named persons in an earlier comparable order, the earlier order continues to have effect to protect those named persons. Applications to vary a nationally recognised DVO can be made in any state or territory. So for example, a Queensland order can be varied on application to a New South Wales court, and the variation has effect across all states and all territories of Australia. The court hearing the application retains the discretion as to whether to hear the application and the legislative amendments in each jurisdiction detail the matters in which the court may consider. Information can now and will be shared across borders between police and courts through a new national database. Therefore, applications orders and court results can now and will be added to this database, which is available to all police agencies and court agencies across all states and territories of Australia. If an interstate agency requires documents from another interstate agency, the legislation now compels the other agency to provide what is reasonably required for the purpose of exercising law enforcement functions. So if you'd like to find out more, please visit our website www.emfl.com.au or give us a call on 07 3211 4920 to arrange an initial meeting today. Thank you.